Legacy ain't just a will, it's how you love or how you feel. What you choose to break or heal, that's the truth your people feel.
Hello, everyone. I'm Donna Marie, Death Doula, celebrant, end of life planner, and love legacy guide. And today I'm joined by Ryan Hamilton, New Orleans attorney at law, and we're talking about estate planning with a Louisiana focus, how succession works in Louisiana, and what families often wish they had known sooner. Before we get started, please subscribe to our channel, hit that notification bell, like our content, share our content, and share your comments. We want to hear from you. I am the host of the Sacred Moments video podcast, and this podcast is a soul-rooted space created to normalize heartfelt conversations around mortality, grief, love, legacy, and end-of-life planning. What you offer to the audience today, as well as to me as a death doula, is going to be so valuable. So I want to just introduce you, and then I want to hear more about you, because this introduction is lightweight, and I think I can hear from the way you speak, you from New Orleans, just like I'm from New Orleans, but I'll let you tell me more. All
That
right.
is correct.
So
Okay.
Ryan is the founder of the law offices of Ryan C. Hamilton, a law firm based in New Orleans, Louisiana. He's been practicing law over 10 years. He's a graduate of Southern University Law Center, and he also attended Hampton University, so straight up HBCU. His focus is on succession, trusts, wills, donations, estate planning, real estate law, as well as business law, and DWI matters and traffic matters. And so, again, Ryan, I appreciate you being here today. I shared a little bit about you, but I would love to hear more about who you are, where you're from, and what caused you to decide to practice this type of law.
So I guess well you finished up there that I did DWIs and traffic tickets. So that was kind of where I started. Is doing that and then some type of way successions and wills and trusts have always come around. My father's a real estate broker, and when you're selling real estate, there's always, if somebody passes away, you can't sell a house until you do the succession. So that work just kind of came my way. I guess I had a knack for it, and there was a void, and then I just started doing it. In addition, I've always done it, so I've been practicing for 15 years now.
Okay.
And my very first case was a will, if I that I never got paid for. I believe the lady came
Oh,
to my
wow.
office 16 times and finally signed a will. And on that 16th day, she said she didn't have any money to pay for it. So that was a valuable lesson that I learned there about the business of law, not necessarily how to do wills and donations and things like that. So it's always been there, but I did more DWIs, criminal law, traffic tickets, things like that. As a younger lawyer, maybe that was more exciting. And then COVID hit, and naturally the courts and everything closed, and people were dying at a higher rate, of course. And so that increased the volume of successions, wills, trusts, donations, all of those type of things. And I started doing that almost exclusively shortly after COVID.
We are here to talk about estate planning. And so I want to first ask you to define real estate planning, estate planning, succession planning, a lot, probate. What's the difference? And then, is there a difference between litigation lawyers and succession? Is that the same?
Litigation can happen in any type of law, right? And so in Louisiana, we call the process of passing someone's property, assets, and or even liabilities over to the next generation, we call that a succession.
Mm-hmm.
Every other state calls it probate, right? That is the name that you would know it by. Routinely, we have uncontested judgments of possession, which means that the heirs come into court and they just say, "Hey, Yana, this was my mom's property. We are all her children. We just want to put our names on the house." The judge looks at everything, whether they had a will or didn't have a will or not, and then he says, "Okay, great. Here's the judgment. The property is now yours." And then you file that in the record, and that's a judgment of possession. And now the property, on the public records is going to show that it has the children's names or whoever was supposed to get it, right? Could be grandchildren, could be a brother, cousin, who whatever the will said or whatever the set rules say where the property is supposed to go if they didn't have a will. That is an uncontested succession where that's not litigation, right? I mean, it's you technically are opening a lawsuit, but no one is contesting anything. It's, you know, there's nothing there, right? There's nothing to fight about. We all agree.
Okay.
Litigation can come in the form of any type of suit, but in a succession is typically when, two heirs are not agreeing, right? It's it could be that, hey, that will's invalid. Mama was out of her mind when she signed that will and said she was going to give everything to Joe. And so whoever, Bob, comes into court and says, hey, hold up. That wasn't supposed to go that way. That's litigation, and that obviously can get costly because it's unknown how much we can go back and forth, right? What sibling is going to come and say this? You may have creditors who are old that are going to sue the succession because, if the house had a mortgage on it, they're going to want to step in and make sure that they get paid before things are transferred. Um, and even after, maybe say everybody's agreeing, it goes to the judgment of possession, and now it's in, and technically this is not probate anymore, but the children may not want to own it with each other anymore, right?
Mhm.
Especially if there's, eight, nine, 10 heirs sometimes much more, 20. I mean, I routinely see successions where, it was the grandparents' house and they had, I don't know, 10 children. And some of them had passed away and they had multiple children. And then so when you go do the judgment of possession, you have to put the property in, you know, 30 people's names. And then that
Yeah.
becomes impractical. And now one of those heirs may want to sue everybody and say, hey, I don't want to own it with y'all. Y'all need to buy me out or we need to sell it to a third party. So litigation comes in that form as well. But it's just basically litigation is anytime, you're going back and forth with court processes.
So do you do the estate and real estate and litigation? Or is there
Yes,
like a separate attorney just for litigation? I guess in some cases there could be,
could
but
be. And what happens is sometimes you don't you don't know you're getting into litigation. It's uncontested, and then all of a sudden, you thought your will was good, and then somebody comes and say, "Well, that couldn't be a good will." So and so had dementia. There's no
yeah.
way they had the authority to write that will. So now you know, you're forced into some litigation, whether you wanted to or not. So, but a lot of people. In general, some lawyers just stick to I do transactional work, right? Like I'm only going to do estate planning. I'm only going to do things in my office that I control that is not before a judge. Like they're only doing uncontested things. And then you'll have litigators who, I don't have time to do a will or this because I'm working on this big case or whatever, right? And then there's a lot of us who are in the middle that kind of like, okay, I'll take your will, and if it goes to litigation, we'll go that way. I tend to not take on a lot of litigation cases because, of course, it's time consuming, and I'd rather be in the office, talking to people about estate planning and doing trust and setting up to avoid litigation. That's what I'd rather do. But we all got to keep the lights on. So
Yes, and yeah, I will say personally, if I um was involved in litigation and I started my estate planning with you, I wouldn't want to meet another attorney and have to start over building a relationship. So I like that you do it all. That's probably comforting to a lot of people. So let's define a few terms, two terms at least for now: estate planning and real estate planning.
real estate planning would just fall into estate planning.
Okay.
I think estate planning is the overall, like, so estate, just your blanket estate is everything that you own, right? So that could be comprised of real estate, bank accounts, cars, businesses, whatever, money, gold bars, whatever it is, new age stuff, crypto, Bitcoin, whatever you have, right?
Mhm.
So when you do your estate plan, naturally you would talk, if you own real estate, you would talk about the real estate. So I don't think there's a specific real estate planning thing. I think that would fall under estate planning, which is basically what your estate planning is. You're directing what will happen with your things after you pass away, whatever they are. Who gets what? Who gets the right to use it? Do you want to sell it and give them the money? You want to give them a right to live there? All of that stuff. So that is your estate planning. Real estate, obviously, if we're talking about real estate, we're talking about, property, houses, land, you know, commercial buildings, whatever the case may be. Um, if you want to plan for that, I guess you can call that real estate planning, but I really think it would just fall under just general estate planning.
Do you know, have you heard of a death doula? And do you know what a death doula and an end of life planner does?
Yes, coincidentally, I have a good friend that was thinking about taking the train. My wife is a birth doula.
Okay.
So I understand on a high level what it is, but I don't know a lot of details. And I think I should know about it, and I think it would help a lot because I mean, if we're talking about estate planning, what happens after you pass away, um, we certainly I could use some of that, especially with my clients dealing with them after their loved ones have passed away or if they're very close to a loved one passing away. Routinely in our community, successions don't happen for generations. And so
Mm-hmm.
some of the trauma and grief has worn off. But sometimes I'm having people who, they have a young child and their husband just died and they come and see me a week later, right? That's tough when that person is sitting across from me, or their mom just died or their husband just died, last week, right? And so I think I could certainly benefit and I would love to hear more about it.
Oh, great. So I would love to, first of all, partner with you in any way possible. And so so there are many names. We call ourselves death midwives, death doulas, soul doulas, end of life planners, end of life doulas. So there are many, many names. This work is ancient. The naming of it is what's new about it. Um, but death doulas specifically work with, I mentioned earlier that I have a client who's in hospice. So we work with people who have a life-threatening condition and we help them. We provide holistic support, emotional support, companionship. We help them have legacy conversations, create legacy projects, make peace with dying, because many people for their entire life avoid ever thinking about the one fact we know for sure is that we're going to die. And just helping people to make peace with that, helping their family members to identify the signs as end of life is approaching, helping them with rituals, um, vigils, and helping family members know how to relate to the person who is actually transitioning. In many cases, a loved one can, just the look of illness or end of life can be very hard for a family member, not knowing the importance of touch, not knowing that hearing is one of the last senses to go, and that it's really important to watch what you say, first of all, around them because they can hear you, but secondly, be intentional about what you say around them because they can hear you. So if there are any messages that you want to share, you should and you can. But also helping with forgiveness. A lot of times we hold things in our heart that don't really matter in the big scheme of life. And at the very end, we're experiencing regret. And so, in many ways, a companion care death doula is there to help individuals process all of what they're going through, to hear, to hold space, and to listen. The person who is transitioning is the person who guides the process, whatever that person needs and whatever their family needs is what a doula is there to provide. Now, when a person is in hospice, there's also a hospice team. So there's a social worker, a chaplain, a nurse. Um, One hospice here in particular offers a few massage therapy sessions, and they're volunteers. So it's a whole group of people helping to support this person at the end of life, and they're communicating with one another. An end of life planner, who is a doula, helps people to understand what their needs are, or learning. They can pay me less money and learn rather than pay you top dollar to learn. And so then when they get to you, that's less you have to do. You can spend the time with them in many cases, the whole process is intimidating and they may not ask questions. They may not get the information they need. And then later they're updating their documents or they're ill prepared because they didn't think about everything that they need or share everything with you. I also, as an end of life planner, believe, and you tell me what you think of this, that there are, so I asked you about estate planning and real estate planning.
Mhm.
Is an attorney absolutely needed for estate planning? Are there, so for instance, I'll just use my mother as an example. My mother has no property. She lives in Louisiana. She has a car, so she does have property. Take that back. She has no major assets. And so I believe I can help her do her without the help and the expense of an attorney. I can help her do her last will and testament. I don't know if an attorney is absolutely needed for that. I don't think so. It just needs to be notarized. And you tell me, do I need an attorney for a durable power of attorney for her financial and medical or an advance
Um,
directive?
I mean, you at the very least need a notary.
Yes.
And then, you don't know what you don't know. And I don't know every law in DC, Maryland, or Virginia, but in Louisiana, those documents need to be in authentic act. So a power of attorney, whether it's durable or not durable or springing, whatever the case may be, it is a document that needs to be passed in front of a notary and two witnesses.
Yes.
So you may not need a lawyer, but you would at the very least need a notary to do a power of attorney. Um, Using your mom as an example, and let's get rid of her car, right? Just for
Mm-hmm.
simplistic purposes. If
Yes.
all she has is bank accounts, insurance policies, and anything that has a named beneficiary, she can certainly go to the bank, put her name beneficiaries. I believe in all 50 states you can handwrite a will. You don't even need well, I don't know about all 50 states, but probably, but for sure in Louisiana, it's called an holographic will, and they call it a holographic will in some states,
Mm-hmm.
but it's the same principle. Um, it's completely done in the testator's handwriting, which is the person who's making the will, and it's signed and dated on every page, and it's clear what their intention is to give their property, right? So if you follow that and the person is able to handwrite their will, um, that's a good will. People call me all the time when they're in the hospital and they want to. I'm saying, can she write? She said, let her write her will out, handwrite it. Now, at a later date, two people do have to testify that that is in fact her handwriting, right? And then
Mm-hmm.
so there, you know, there will be some things that will have to happen later, but understanding though the will is just instructions to the court. So if you don't have everything in order, if you don't have beneficiaries and all your stuff, it may go back to court and then you would have to hire a lawyer to do a succession. But
Yes.
if somebody doesn't have real estate, you probably are taking away one of the main reasons, or own a business. One of the main reasons you would want to do um, a will or a trust or some type of plan, because most of your other assets have named beneficiaries. And even in some states, I'm pretty sure Texas is one of them, you can name a beneficiary on a house. And DMV might be like that too.
Yes.
I don't know if is that
It
something you
is.
can
Yeah,
do?
they have
Okay.
transfer on death deed. So, yeah, so the deed transfers just like so with a bank, you said name beneficiary. So just for the audience, payable on death. You go into the bank, you give the name of the person you want to name as your beneficiary. It's called payable on death, and you need the social security number, persons that you're adding as a beneficiary, their name and social security number, and then your bank account when you present a death certificate your bank account automatically transfers. And yes, that's also in the DMV is offered. That's an option when you have real estate transferring it on death.
Yeah, I think Louisiana is probably in the minority where it's still where that doesn't exist. So I think most states have something like that, but I think everybody should check, with their state to see what the rules are there. The only thing I would suggest, And I tell people all the time who fall in the category that like your mom falls. They're like, look, I don't either I never owned real estate or I sold it or I donated it already or whatever the case is, and I got all my accounts and my policies together. I still think you need to do power of attorneys, right?
Yeah.
You need to appoint someone who can access your banks for you, someone who's going to make your medical decisions, who's going to determine if you go in a nursing home or not, if that's necessary. So if you have multiple children, you might want to pick one, right?
Right.
To avoid confusion. A lot of times I have families where they have a majority vote of the siblings, right? They have three, four, five children, and they say, oh, the majority wins when it comes to making decisions about, the parents' care or whatever to do with their money. So I,
Yeah.
there is to long-winded answer. I think there are some circumstances where, yes, technically if you have, certain type of assets that can just be payable on death or transfer on death, then maybe you don't need to do a trust or a will or other those things. Just a power of attorney and have a notary notarize it.
So another thing, just you made me think of another thing death doulas help people with. First of all, body disposition, creating those advance directives, making sure that they've designated a healthcare agent to make those decisions and to understand the importance of it. So for many people, they think, oh, I'm married, I'm gonna name my husband. But if your husband really doesn't think through decisions, or your husband might be too emotional to make certain decisions, or would not feel comfortable making a decision, then it might be better to choose someone else that you know will honor your wishes and value your values and honor your voice. And so death doulas are really at the core of the work we do is activism. It's making sure that people live and die with dignity. That brings me back to estate planning. I think it's much easier when an attorney can be hired and everything is in one place. You have this one person you can reference and go to and build this trusting relationship with. And then, so I guess the question I have next is estates, and you and I had a long conversation about this estate planning in a trust. So, and I'll just share my own experience based on our conversation. I, so Louisiana is a streamlined succession state, is that right?
Yeah, if it's under a certain amount, if it's under
Yes.
100, if the property is under 125,000 and a few other stipulations, but the main thing is that the value of the property needs to be under $125,000 in order to
Okay.
use that streamlined affidavit of small succession.
Can you explain what that is before I go on?
Yeah, certainly. It's just a document, so it's going to cost substantially less than doing a full-blown succession. So it's just abbreviated process. You don't see a judge, you don't go to court, you just file it in with the clerk of court. And that can be done at a lawyer's office.
Okay. At first I thought, I don't need a trust. Why would I need a trust? And I have two children. They are
Mhm.
both my beneficiaries. They're adults. My property transfers to them and they split it. But
That's
then
right.
one thing you told me that made me realize the importance of me having a trust is that anybody can contest my will.
Right.
And because it's a will, then I got to go in open succession. The trust is private. People are less likely to know details about my estate. Not only that, I skip the succession process. And a lot of times when people are grieving and hurting, the last thing they want to think about is, okay, I got to go do this process to get this.
And
And
that's the main thing. If you have to do some type of probate process, if you do a will, that is simply instructions to the court on how the probate process is going to go, right? And so there are things that if I'm a creditor of the estate, I certainly can come in and affect what's going on in that succession because I need to get paid my debt, right? And so you can't have a judgment. You can't just transfer property with a mortgage on it in a succession, right? That though that debt would have to be addressed, your heirs would likely have to go get refinanced to get a new mortgage, and they would have to qualify. They can't just take over the payments. They can't just put it in their name and take over the payments. The bank is not going to let them do that. But if it was in a trust, because the trust is the entity that it continues on and you're just switching parties, then your heirs can continue just paying the note. They don't need to go see a judge. You've already, if you do a trust and you fund it properly, which means put everything that's supposed to go in it, then your children or whoever you want to leave your things to don't have to hire a lawyer, don't have to, go before a judge to get control of everything. They just have to present your death certificate, almost just like like a payable on death thing, right? You just go to the bank. Hey, I'm now the trustee. I can take over these accounts. If they wanted to sell your property, they could just give the closing attorney, look, my mother passed away. Here's a trust document that says, I step up into her shoes. That's it. We don't need to get a judge, the appointed administrator. You kind of go, you're with the trust, you're circumventing that process, right?
Yes.
You're getting out of probate. And as far as litigation goes, it's not impossible for someone to sue a trust. When you have a will, you have to open up a succession, and you immediately have a file number that now people will start sending claims to. It's automatic. When I open up somebody's succession, immediately all the bill collectors are lining up and sending notices to say, hey, this is my claim. This is my claim. So you because it's not private, because it's public record, all of that, you just create an area where it's much easier to contest. And it's not automatic, right? Even if you do a will, if you keep your will in, sitting in the room somewhere, if your children never take the step to go get in the position to be the executor or, get it transferred over to their name, then it doesn't happen. And now property is sitting in, I do successions for people that died 100 years ago. 100 years ago and generations later. Like that, those are the extreme cases, but I've done more than one of them. And I routinely do successions for people where the property is in their grandparents' names all the time. That happens almost almost every case. That it is a generation skipping thing. So if you do a trust, you kind of avoid that process altogether. It's the VIP service.
Yes.
And your heirs won't be doing it in a time of grief, right? And if we're talking about, death doula, it's certainly to make the load, lighter on the heirs. A trust is a better way to go. Now, a trust does cost more money, but the good thing about it is there are a lot of things that you can do for free, like you said earlier. Like your estate plan might not include a lawyer, right? It might not. If all your assets are payable on death or transferable on death, then maybe you don't need to do a trust unless you have a want to control the money beyond when you pass away. Because in Louisiana, you cannot put restrictions through a will and a succession. You give it to them through a succession. It's theirs. They can do whatever they want with it. There's no saying you can't sell it. You could only use this money for a specific purpose. No rule. You can't put any rules. But if you do a trust, you can place rules and restrictions on what you're leaving people. So that is another reason some people, even if they don't have real estate, maybe they have a significant amount of money and they don't want to give that money over to a 20-year-old or even a much older person who they think shouldn't have just outright control of the money. They'd rather, give them a monthly check or a yearly check or whatever.
Relates to succession and a trust. I was thinking you pay up front or you pay on the back end. Either way, you're gonna have to pay,
Either way,
right?
you're gonna have to. That's right. That's right. And you
So
probably will pay more on the back end.
you get this maybe hefty dollar amount up front, and it might be intimidating or might you might think you can't afford it. But technically, what you can afford is not doing that and having your property go through succession or having it made public and somebody being able to contest it and messing up your wealth in so many, many ways.
Yeah, absolutely.
So you
Absolutely.
protect yourself. And then, so the example I was thinking as you were talking about someone with a lot of money. So if, um, somebody had a $20 million life insurance policy
There you go. Yeah,
and they had a 20-year-old child,
absolutely.
that 20 million would go directly to the child and could
Yeah.
cause that child all kinds of problems if you just lay $20 million in a bank account. And
Yep.
in 10 months,
It could be gone.
it could all be gone,
Yeah.
right? If you like to be in control, having the terms outlined in your trust is your last act of control. But it also protects people because I don't know what I would do if I had $20 million or how I would respond. So, so it's really important for a person to be able to consider their loved one, and to make choices that would benefit them beyond the grave. Like, so that's so important for people to think about. Something else I wrote here. Oh, funding the trust. Can you help me, or help the audience and me understand what are the steps of funding a trust, and what is that? You mentioned the deed being able to transfer. How does that process all look?
So, when you establish your trust, right, it's essentially it's an empty box, right? You go to a lawyer's office, they're going to draft you a trust, and it'll have all these terms of what you want to happen, and it can even talk about property. It can say what to happen with that house, or what's going to happen with this bank account. None of that matters until you actually put the things in the box, right? And so that's going to be going to uh, any issuer, right? Like, so if it's a bank account, you need to go to that bank and let them know, hey, I have this trust. I want to change the name um, of this account to the trust account, or I want to name the trust as beneficiary. With real estate, it's going to be actually transferring the property into the trust, which is done by, and it depends on your state. They may call it all different things, but some form of deed, a quick claim deed, a warranty deed, an active sale, an active donation. They may call it something else in some other state, but however you transfer real estate, you need to transfer the same way you purchased your home. You need a document like that to then put it into your trust, right? You need to the county clerk or the parish clerk,
Yes,
in Louisiana needs to have on record that you don't own the house in your name anymore. The trust does, right? And so at that step of doing that is funding the trust, putting the real estate in. If it's a LLC or some other corporation or something like that, that Secretary of State needs to have on file that trust is now the owner of that business. You personally don't own that business. The trust owns it. So that is another example of funding. And routinely, it's easy to transfer property that is in LLC. So you would keep, if you have a LLC or S corp or corporation, whatever the case may be, anything that's owned in that corporation name, you leave it in that corporation name. You just update at the Secretary of State who the owner of that corporation is. So all of that stuff kind of flows into your trust. So that is another way of funding your trust. You can then specifically open bank accounts, brokerage accounts. You can get insurance policies in the name of the trust. A lot of times people do irrevocable trusts for life insurance policies. They call them ILETs. There's tax reasons for that. Because it depending if you have a big $20 million insurance policy, you probably want to have it in an islet because now you're getting over if it was in your name, you're getting over the federal limit, and then anything over that 13, 14 million dollars, you have to pay 40% on taxes. But I don't know, us mere mortals don't have to worry about $13 million dollars per spouse, almost
Wow.
$14 million dollars per spouse. So you need to. I routinely have clients who contact me about doing a trust for tax reasons, and I have to tell them, well, yeah, I, I don't know, maybe you might have this problem, but if your estate is not anywhere near $28 million, then you don't need to worry about taxes. And they're like, well, what's all this about taxes and trust? Well, you need an estate over $28 million in order to do that. But there are some states that have an estate tax that is a state estate tax or a state inheritance tax that is much lower. I don't know what they are offhand, but some of the limits are much lower, like $500,000. If you
Right.
own a property in some states, that's enough to get you over the $1 million. So
Yeah.
it does depend. What state you're in, it might be a good idea, but I don't know the ones offhand. But it's only like three or four of them that actually have a state level estate tax. Louisiana is unlimited. I know Texas is unlimited. So it doesn't matter your estate size, you'll never have taxes in Texas and Louisiana.
I want to go back to funding the trust. And so
Okay.
funding the trust is the responsibility. Let's say I'm your client, is my responsibility to fund the trust. An attorney may or may not offer advice on how to do that, but I got to do all the legwork. So I got to go to the bank. I got to do this and I got to do that.
I take care of the real estate. I factor in what that county the county clerk, for the sake of, of this podcast, is going to charge, right? I mean, it's I can calculate within a good reason, if you have X amount of properties and how long the document is or whatever, like what the clerk is going to charge, and I at least put the real estate in the trust,
Yeah.
right? Then people's bank accounts, they've got to go around to the bank accounts, to the insurance policies, to all of that stuff and figure that out. And that's a job. And I think ultimately some clients decide, I'm not doing this job. I'm leaving all my stuff to them. They're gonna have to do this job themselves. But that's a decision that each person has to make. Do you want to roll out the VIP carpet and take care of this thing, or you know, let them do
Yeah.
it?
I think like I have one cousin in particular. What he says is he worked hard, he earned his money, and when he gone, fuck them kids. Like I'm like, well, how do you say that? You invested your whole life raising, or their whole life raising them, and then your assets. What he's really saying, which he doesn't know he's saying, is that everything he has worked for doesn't matter to him because such a selfish statement, right? I don't know if he realizes how selfish it is, but everything you've worked hard to earn and attain, all of your assets are meaningless to you because you're not here anymore.
Right. Yeah. Yeah. Let them sort it out. And
Right. And
I
they could lose
have,
it all,
yeah.
or the bank could take ownership of it because they like fuck my dad, right? So
Right. Yeah. I mean, and those folks, I hope at least they would decide to do a will, right? If you have multiple children, right? Different assets, you know, at least do something, have a plan, right?
yeah.
I don't really suggest to give it to them ahead of time, but, you know, at the end of the day, it's a plan, right? I had a client in the office last week and we were talking about wills and trusts, and she said, "Nope, I'm giving it to him right now." And I'm like, "Okay, the only problem with that is now she doesn't own her home anymore, right?
Right.
And now her daughter and her husband, any of their liabilities now attached to her property. And so then that is from a from a legal standpoint, I'm like, yeah, man, all the liability point, that's probably not a good idea. But from a pure like estate planning process, it's like we're not dealing with wills, trusts, none of that. I'm giving it to them right now. They got it, you know. And so it's rare that I have a client that wants to do that. Most people do not want to let go of their things before they're gone. Just like you said, he like, hey, I'm gonna hold my stuff and let them figure it out when I'm gone. You know, a lot of people want to at least control their asset while they're alive. You know, and direct where it goes when someone passes away. But that is an estate plan as well.
You,
Um,
you, as you do say that, um, that puts a person in such a vulnerable position, right? Because you lose your own agency. You can't take care of yourself. And so if you need um, end of life care,
mhm.
you living in somebody else's house, you lose agency. You lose the ability to care for yourself when you've depleted or given away all of your assets.
Yeah, and then a lot of people say, "Well, we don't plan on selling it, and I'm never gonna mortgage it." Well, I mean, you never know. I don't like the reverse home mortgage deal, but I mean, some people have no options, right? I mean, and now you've given away the thing that you could sell, you could mortgage, you could do whatever, like you say, to die with dignity, die the way you want to, have the care you want to and you've given away your assets. So, and
Right.
then if you've donated a thing of value and you need to qualify for Medicaid, that brings in another thing. If you're in that 5 year look back period,
Right.
now you've disqualified yourself. So there's all type of reasons to not give away your things as an estate plan. But it can be a plan, and some people do it, but I do not suggest it at all. And we have a lot of the planners who willingly do nothing.
Hmm.
I find those are the men who have remarried, and they may have children from their first wife, and maybe no children with their second wife, or one child with their second wife, and they can't figure out how they're going to fairly uh, distribute their assets. So they decide to do nothing. And once again, I don't think that's a good idea, but that is one of those that is an estate plan. You've opted
Right.
for the set laws that are gonna make sure that everybody is involved in this process, no matter how much chaos and money it will cost for that to happen. Everybody should probably try to find a free consultation to figure out what it is that you don't know, right? There's an
Right.
abundance of people that don't realize there's another step after you do a will. A whole bunch of people say, "Well, I got the will. The will said, I'm the executor in this." And well, that doesn't matter until you brought that will before a judge and they've
Right.
approved it and it's in proper form, and it's a whole other step. So a lot of people don't realize that. A lot of people don't realize a power of attorney terminates when a person passes away, right?
Hmm.
I'm the power of attorney. Well, yes, that was only for their life. It terminates when the person passes away. Louisiana's power of attorneys are by nature durable. Largely, most other states, the default is not durable, meaning you have to specifically say that, and I guess we should define what durable is, meaning I'm in my right mind right now, and I say you have the right to make decisions for me. If the power of attorney is not durable, then that power of attorney ends when I lose my mind.
Yes.
For a simple explanation. If it
Or
is
you're incapacitated.
the legal term, incapacitated, determined by two witnesses, right? When if it continues even when I'm incapacitated, then it is a durable power of attorney, right? But even durable power of attorneys end at death, right? They don't
Hmm.
they don't continue on past that. And those are some of the two biggest misconceptions. When people call my office and say, I got the power of attorney in the will, it's my house. Maybe, right? We
Right.
don't, no one knows that yet. No, it's still, if you look in the public record, it's still in your grandfather's name or your mom's name or your husband's name, whatever the case may be, you got to go and take that extra step. So, not that everybody needs a full-blown, trust and this and that, right? But contact a lawyer and find out. A lot of lawyers will give you a free consultation, right? Find a lawyer that'll give you a free consultation or pay for one. Pay, some lawyers $50, $100. I don't know.
Right.
Maybe that's a lot of money, and I shouldn't suggest that, but figure it's probably not a lot of money if you have a house, right? You
And
should.
if you have a house, it you got to figure out a way to make it not a lot of money because you chose to invest in a house. And if that matters,
If that
then
matters, yeah, you could spend $100 to figure out how to protect what you worked for your whole life.
correct.
I would agree. I hope I'm not being,
Well, one
not
thing you said is when you don't make a decision, you still are
making a
are
decision.
are choosing, right? You are still
Dude,
making a decision. There is no such thing as no decision. No decision or doing
is it
nothing is a decision that
you let the
has
state?
consequences. Right, right. So either you want to be in control of the decision and intentional about the decision, or you want to lose your autonomy and leave a mess potentially for the people you love.
Yes, that is correct. So I mean, you could spend $100 and determine that the set rules work for you, but you ought to at least get there, right? Because as we said, everybody doesn't need it. Like you started out with your mom. Your mom certainly does not need a trust, right? I mean, it's kind of like, I assume I don't know who she's leaving her stuff to, but you seem like a responsible person that can handle your affairs. And let's say she's leaving it to you. There's no reason for her to limit what you have, spend a trust, do all of these things, right? There are a lot of people who are they think my children are responsible. I don't need to limit them. I don't have any real estate. Then there's no reason for a multiple $1,000 trust. You could do a power of attorney, and if notaries will probably do a power of attorney cheaper than um a lawyer would. I don't particularly like LegalZoom documents, especially for Louisiana, because we don't have the same words, right? Any other state, maybe
Right.
LegalZoom might be a little bit more effective, but Louisiana has different words, and if you don't
A,
say
a different system that you practice law differently.
so
Like
Napoleonic Code, civil law, right? We have
the
civil law. Everywhere else is common law. It's developed from a different system. It's a lot of the same concepts, but they have completely different names. And if you don't use our magic words, they don't count, right?
and
Like
everybody know we got magic words for
we got
everything.
magic words, and if you use those other states' magic words, right, then it's not effective. Like an independent administration is probably the main thing. I see time and time again if somebody's got a will from LegalZoom or some other online place, they may describe what an independent administration is, but they fail to use the words independent administration. That's not an independent administration. You did not, the code specifically says you need to say it is a independent administration, not describe what it is, right? And so if you describe what it is and you use, I don't know, some common law term, then now you failed. And I think that's every state probably has different quirks. I think Louisiana is the most different from all
Yeah.
the other states. And so find a lawyer to give you a free consultation to figure out what you're doing. I tell a lot of times I talk to people and I'm honest with people, but
Right.
talking about we're talking about your life personally because you're giving someone the power to make decisions for yourself, financially
Right.
and medically. And we're talking about where your life's work, your estate, wherever that will go.
So I just learned a word. Oh my goodness. Oh, is it legalette? Is that
Legalese?
legal? Wait, no, that maybe not. What's the one where, yeah, that might be the word where the person it leave, that's who you leave the legacy to. Is that the word?
Oh, legatee.
Legatee. I was like,
Yeah,
that's
yeah,
a
yeah,
that you
yeah.
could do a bounce song to that one.
Yeah, legatee. You might like that might be my little commercial. We
So
clip this up right here.
yes, yes, I want my royalties. I want.
You got it. You got it. Look, I said right here that she gets her royalties.
um, but that it's about your legacy. It's like, what do you want to leave? And to the people you love. I have two children, they're adult children. If my son decides I want my money after I'm gone, or I want my half,
Yeah.
that could be a fight.
That could be. And if you just did a succession, he could have the right to do a partition. But in a trust, it could say this property cannot be sold unless
Right.
both trustees agree to do so.
I get to still be mama
You
from
get to still be mama. That's right.
yes,
That's
yes,
right.
yes. And
Yeah.
so I get to still think about what's best for my children. I get to think about scenarios. I get to think and I get to have conversation. The most important part of the work I do is encouraging people to talk about these things before, like it, even like how where you want to be buried, how if you want to be buried, whatever it is.
Mhm.
Nobody should be making these decisions without you having a conversation. You can read a document, and the document might mean one thing to my daughter and one thing to my son. And so, having the conversations with your loved ones and making sure they're clear so they're not fighting because they understand a word differently or comprehend something differently is so important to have those conversations. Um, so, what's my word again? Legally.
Legatee.
Legatee. I gotta get listen.
One thing I wanted to touch on is you brought up royalties and music rights. That's so important for all the musicians we have here in New Orleans. That's another thing that needs to be addressed, right? I think you can name beneficiaries on that, but you still got to go and do it, right? That's something that people need to update. Whatever type of property you have, everything you own, you probably can name a beneficiary on it if it's not a house and not a car. And in some states, you could do it, you could even do it on a house.
So estate plannings are not for people like what's his name, Tom Benson, and them.
Yeah, yeah, right, right,
It's for all of us, particularly Black and Brown people, like especially after Hurricane Katrina. Like we really need to think about making sure that whatever we've worked hard for, you don't build anything on a rocky foundation. You got to have a solid foundation.
right.
Otherwise, whatever you build, the structure is not secure. And so the basic things in life are very, very important and to just have a basic understanding of what you need. And like you said, you offer free consultations. There's always a will. I mean, if there's a will, there's always a way to get the information you need. Death doulas or end of life planners are here to help you. Also, I got a few more questions before we wrap this
Oh,
up. Earlier we were talking about the trust, and when you fund the trust, I wrote this down. You says you don't own the home anymore. I'm like, that could be alarming for some people. So I wanted to address that because that
yeah.
could turn people off. Like, I ain't gonna own my home anymore. And we just talked about what does that really mean? I don't own
Right,
my
right.
home.
You don't own it in your own name. You manage it as the trustee of your trust, and you benefit from it as the beneficiary of your trust, right? So there's three parties to a trust. It's the same name, but the first party is the person putting things in. It's anything with the or, settlor, trustor, grantor. That's the person who is putting property, things, assets into the trust. They give those things to the trustee. And 99% of the trusts I do, the grantor is the same person as the trustee. The trustor and the trustee is the same person. So I, Ryan Hamilton, give my things to my trust and I hand them over to the trustee, Ryan Hamilton of the Hamilton Family Trust, right? And so now I don't own it anymore. My trust owns it, and I manage it as the trustee. And then I am also the beneficiary of my trust, so I get to benefit from anything that's in my trust. So technically, on paper, you do not own it. You manage it and you benefit from it because you gave it away. It's no longer in your estate, it's in the trust estate. But because those parties are the same people, right? It's not, the trust is not really an entity separate from you. Because if you're all three parties of the trust, like it's just you.
Father,
That's
Son, and the Holy Spirit.
yeah, you're the Holy Trinity. You know what I mean? So it's not until you pass away or become incapacitated that we're going to make a change to the trustee. When you pass away, we'll make a change to the beneficiary, and that could be, like, your children, that could be your spouse, your girlfriend, that could be whatever, your mom, whoever you put as your successor beneficiary then steps up into that position. And that's why you don't need to go do a succession or probate, is because you yourself, your estate is empty, right? You don't have anything in your estate because you put it all in your trust and it's in your trust estate. And the rules about probate and succession do not apply to trust, they apply to people's estates, right? And so yes, you don't own it anymore, but as long as you are the trustee and the beneficiary, then you control it. Now, this is where a lot of people call me about asset protection through trust. The only way to do that, and in Louisiana, it can't even be a self-settled trust to do this, but you have to then give your things away and someone else has to manage it. So, and then the trust becomes this entity that's separate from you and ran by someone else. So even if you wanted to do that for like your children, you can make your children the beneficiaries of your trust, but you have to have a third party who's going to be the trustee. Uh, and it's like, who do you trust that's going to manage all your things for your children? That's a tough question sometimes. I mean, a lot of times, you have a sibling or something like that, you can have that plan in place to be able to carry that out, or a good friend, cousin, whatever the case may be. But some people have to use a third party trustee, corporate trustee, and they're going to charge money, right? And so then you've got to figure, do you have an estate that could sustain that? For some people, where it's a grandparent that's given to a grandchild, and then they put, the parent as the trustee and the grandchild as the beneficiary. And a lot of times you're doing that with money that you're giving to the child, and you want to make sure it's safe. Like, you know, I want to get whatever, $10,000, $50,000, $100,000, if you're blessed to just give that type of money away. I want to put this right now separate from me and my liabilities, separate from everybody's liabilities. I'm putting this $100,000 in here to grow for my grandchild, and they can access this money at age 30, right? And that's a powerful thing if you're able to do that, because 30, if you're doing that for a young child, you put $100,000, and 30 years later, they'll have a whole bunch of money that they're ready to come to. And so that way you can set up a asset protection trust and tax things, but that takes generations, right? That takes time. That is not, I'm gonna come here today and I'm gonna create this trust and then nobody can sue me. It's like, it don't work like that, you know.
Revocable, irrevocable trust.
So revocable, we kind of talked about it a little bit.
Yes.
Revocable is when you have the power to change the trust, make changes to it, get rid of it. 9 times out of 10 in a revocable trust, you are the trustee, right? Because that you're reserving that power. It doesn't have to be, not 100%, but most of the time, by definition, a revocable trust, you have the power to revoke it, right? That's just pretty much it. So you can make changes to it. And so that type of trust is not going to give you asset protection because you're in complete control of the trust. And irrevocable trust is when you've created this thing and you cannot make any changes to it. It's set in stone, and that's where asset protection comes from,
Okay.
right? And because I gave this $100,000 into this trust, I cannot take it back. It's not mine anymore. I don't own it. The beneficiary has no right to access it until a certain age or upon certain conditions. So even if they, get into some lawsuits or whatever the case may be, it can't touch that money. The trustee who's in control of it, it's not their money. They have to manage it for the benefit of the beneficiary. So they can't use it. If somebody sues them, they can't get to that money. So that's why irrevocable trusts are created for asset protection, is when you have separation of parties, when you have somebody giving something to somebody else and somebody else managing it, right? We got three separate people. Then now that is an irrevocable trust that is going to be set up for asset protection. It can be set up for taxes as well. But if you put $100,000 and wait 30 years, that's a whole lot of money. Again, you may be over the estate tax bracket at that point, but because it's in that trust, you won't have estate taxes, right? And so it's setting up for the next generation and thinking decades in ahead that you're setting up with an irrevocable trust.
Okay. Thank you. What is in an estate plan? What comes with an other than a trust? What documents or what
So
is a person paying for with an estate plan?
So a trust is one of the documents in an estate plan, right?
Mm-hmm.
So you in an estate planning, we're talking about your estate and how you're going to plan for everything about it. So we're talking about a will potentially. You could have guardianship documents if you have young children. Um, we're talking about power of attorney, medical power of attorney, financial power of attorney. We're talking about an advanced healthcare directive, which is basically saying whether or not you want to be on life support. So if you do an advanced, it's called a living will or dying directive, advanced healthcare directive. It's got a couple different names. But that document limits the medical power of attorney to an extent because you take away, even though you granted someone a medical power of attorney to act on your behalf to make those medical decisions, you're saying while you're healthy and while you're of your right mind, saying, look, if I get to this point, pull a plug on me. I don't care if I gave that medical directive, if I gave that medical power of attorney to my brother or wife or whoever it is, right?
Mm-hmm.
I'm saying right now, if I get to that point, pull it, so that there's that document. Whether or not you want to be cremated or not. There's that document. You can talk about even if you're not going to be cremated, how do you want your services to go? There's that document. And then you get into the trust, which is probably like the biggest estate planning document is, to obviously go around a succession. And then with the trust itself, there's also you have to have a schedule of assets with the trust. You have the minutes of trust. You have the extract of trust. But these are all just kind of documents that come attached to the trust itself. So that's pretty much all the documents. I mean, quick claims donations are technically in an estate plan because you may start quick claiming some things away now, especially people who have larger estates, right? It's not that big of a deal if you have 10 properties to quick claim a couple of them as you go to who you wanted to leave them to anyway. That's all those documents are just addressing those three issues, basically. Who can act for me now? Where's my stuff going when I die? And who can, address how my body is handled? And if you have children, who's raising my children?
Mm-hmm. Okay. I would like to know your thoughts about how you think a death doula would be a good partner or complement the work you do.
I mean, I think it should be almost included in every estate plan. Like, you know, a midwife and a doula, right? Like
Right.
you probably want a midwife and a doula at your birth. And I
Yeah.
would say, if you're doing estate planning, you probably want a lawyer and a death doula, right? To talk about these things because a lot of people don't do estate planning because it's taboo. I'm not talking about that stuff. Normalizing it in some way, right? In dealing with it and addressing it. I'm coming at it from the legal aspect, very textbook, law book stuff, right? But then there's like the emotional side, like
Yes.
the human side of
The
it, right?
human side.
Like
Exactly.
the family and what's going on. And I think I try my best to have enough of that in it. It should be part of the team, right? Everybody, it's like you get your insurance person and a lawyer and an accountant and a this and a doctor. Well, get a death doula too. If you're
Yeah.
if you're in that category. I mean, obviously,
Well, in the end of life planning should be for anybody age 18 or older. So if you are a 18-year-old and you're, let's say, in college and something happens,
yeah,
you have your own bank account. Your parents can't access your bank account if it's not a joint bank account. Their name isn't on it.
yeah,
Your parents can't access your healthcare records. You might want to be an organ donor. You never had that conversation with your parents, and your parents just gonna bury you in the plot that's for the family. It could be
yeah,
anything. A death doula is there to help facilitate those conversations. We don't just work with people who are at the end of their life. We work with healthy people as well because this whole conversation is about making the decisions before you're in crisis, making the
right.
decisions. And even if the plan is an incomplete plan, at least there are some clues that are left behind to help people. Um, as a death doula, I've created an end of life checklist just so people, even if they never talk to me, is a free checklist. It's just something to put on your mind because nobody wants to think about this. So normalizing this conversation, creating the human, the medical, and the legal, all of us need to be
Yeah,
working together to support an individual.
yeah,
So thank you for saying that. I love that concept of a doula being involved in the process because I'm assuming you seem to be very hands-on and you spend time with your people, but you got a lot of people.
yeah, right. And I'm not in that side of it, right? With the people, right? They come in, and a lot of times I may not. I mean, sometimes with the will, right, I'm gonna know if I did the will and then they bring back the will. I've been practicing law long enough that I am doing successions for people that I did wills for, right? And
Hmm.
so I do have that. I'm starting to get to that point. I haven't done a lot like that, like wills that I've done that people have passed away, and I've come back and now I'm doing their succession or something like that. But a lot of times, I'm doing wills for people in, 20s, 30s, 40s, 50s.
Good.
You know what I mean? And I mean, the estate planning part, sometimes we're so far away from, the grieving part. But I still think that should all be in there. Even if you're saying like, yeah, you're in college or whatever, you're in your 20s, you still buying people don't buy health insurance because they think they're going to die the next day, right?
Right.
So it's the same thing. Like you can make your estate plan, and I think having a estate plan that has a human component, right? Like why not? Why would that not
Right.
be a good idea? And
Right.
so yeah, I would certainly too bad we're not in the same
Oh, we could shake
region.
hands virtually. Yes.
What you have before goodbye is a gift that never dies. What you gonna leave to your legacy? Have you thought about your legacy? Become your own ancestor, yeah.